Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And how are you guys doing? How are you guys doing? I hope you're doing well. I hope you're doing well. We are right on time today. Oh, the holidays are finally ending. And while I love holidays, I also don't. They're busy. They're stressful. They're hectic. They cause disruptions everywhere. But they are what they are. They are what they are. Oh my goodness. Oh, wow. Hey, what's up, Az? Heel versus Babyface says, love you so much. Hey, back at you, buddy. Happy New Year. Happy New Year. Guys, it's been a wild ride for me, okay? It's been a wild ride for me, of course. Of course, I do have to say, thank you all. I did make my goal for 2020 right at the end. And I mean, we're talking, it was down to the wire, but I did pass 100,000 subscribers. I am very, very thankful to everybody who supports me in all of this. And so thank you. Thank you for that. At some point, I have to figure out what I promised to do at 100,000. People are saying 24-hour stream. I seem to remember saying a 12-hour stream. If it's a 24-hour stream, it's going to take a lot of planning. Those are really, really difficult for me and for my family. So I don't think that's what I did. If I promised 24 hours, you got to show me some proof. I'm pretty sure it was 12. But either way, I will, whatever it was, we'll figure it out. But I don't know when it will be. I don't know when it will be. So we'll see. That's what I got on that. We'll see. There will be some sort of celebration. Maybe it might be when I actually get my silver play button and all of that stuff, which I will have to, you have to like register for it and then they have to send it to you. So we'll see. Once I get that stuff squared away, that might be the answer. But thank you. Thank you for you guys, because there are two different audiences on this channel. I don't know if you know that. There are two different audiences. Now, there may be some overlap on some of these live streams. I don't know. We'll see. That remains to be seen. But considering I added 11,000 subscribers last month, which was a big month. But yeah, so if there's some overlap in the live streams, that'll, we'll have to wait and see on that. I don't know that there will be. I think it's largely a different kind of audience. The YouTube demographic information I get suggests that it is a vastly different audience with very different interests and with very different sleep schedules and time. So, that's it. That's it. But I am happy doing both things. Two different audiences, two different types of content. I don't really intend on changing the live stream content in any way. I know that there are a bunch of people out there who really like having a show to watch and a chat to hang out in at this time of night. I'm awake at this time of night anyway, so I think there's no reason to quit doing it. It is a lot of fun. for me. So don't worry about like that stuff happening. There's not going to be like some dramatic shift to away from live stream content or anything. As I said earlier this year, or well, earlier last year, because it's the new one, the show is the show. The show is the show, and the show is here. And so here at this time, and for now, here on this channel, that's the one thing that may eventually change, and I have no plans to change it at this point. No plans to change it, and if there is any change, it'll be announced way in advance. But it's possible, just depending on, I hope YouTube makes some changes that makes this unnecessary, but it's possible at some point that the live stream would move to like a live stream specific channel. But I don't want to do that. I really don't. I would much rather I like everything being here. So, that being said, I'm hoping that YouTube makes a change, because what I would want, the problem that I have is that by the time I do several videos during the day, it eats up all the notifications for the live stream. So the live stream, people don't get notified that it's on. And I mean, notifications for live stream are already weak. But, you know, not having the notifications go out means that less people are alerted to it to watch, which is really freaking annoying. And it's not even hitting the bell anonymity. YouTube only gives you 3 notifications a day. So if they give us some better tools, or maybe I'm stupid and don't realize that the tools are there, if they give some better tools on how to manage those notifications, like I would turn off notifications for basically every short video if I can. And maybe I can. And if I can do that, I will, to like, you know, do something so that the notification that goes out, the one that I want to go out, is the live stream one. That's the one that I care about. Nernieth, could you do 2 vids and save one for the live stream? Maybe, but today I did 5. Because there were 4 things to talk about in one New Year's video. So it's a mess. But the live stream's always going to be here at this time. Maybe I need to put, maybe the community tab is the answer. Maybe every day I have to put one up in the community tab that's public, and that'll be just a reminder on the community tab that there's a live stream at 11 p.m. But can Pence throw out electoral votes from those contested states? It's a very interesting question. I don't think anybody can tell you definitively yes or no. The likely answer is no. Not without Congress doing it. That's the way the law is written. But lots of people suggest that that's unconstitutional. So, can he? Maybe. Maybe is the answer. Probably not is the most likely answer. But we don't know. Anyway. I do want to say, I hope you guys like the content that's coming out. The daily hit content. I'm trying to keep them short, digestible. I'm trying to make sure that every video that does come out has some substance to it. Trying to do quick hits on, you know, if it's legal or political drama that people are really interested in, like the Lynn Wood tweets. I mean, oh my God, Lynn Wood is accusing top Republicans of sedition, of treason. After I made the Lynn Wood video that I just put up a couple hours ago, Lynn Wood has said that Mike Pence should be executed by firing squad. Where are we? And the crazy thing, it's not, I shouldn't say the crazy thing, the wild thing about it is that a lot of people agree. Like we're on the cusp of some stuff here. Like if you haven't, you got to check out the comment section from some of the short videos I've been doing, especially the ones with Lynn Wood. Like thousands of comments so fast. The Linwood video I did 2 hours and 15 minutes ago, okay? Get this. Like, the views that you see on it are lagging way behind. YouTube has a weird counting mechanism where it counts real-time views and reports them to us as an estimate. But, like, the live view counter is broken. It's way behind. That thing is doing 100,000 views an hour. So, like, Linwood is on everybody's mind right now. That video, it's showing like 43,000 views or something. It's well over 200. It's wild stuff. I wish it were monetized, but thanks YouTube for being off today. all of that is not getting monetized for me. It may get monetized tomorrow, but for now it's not. Oh, I would love to have Linwood on the stream. I would love it. But anyway, I hope that you guys are enjoying the non-live content. I'm trying to give you guys and everybody else something fresh, interesting, and just a quick dose of stuff throughout the day. That's what I'm working on doing. So I will be keeping that up. If it is something you don't like, and I know I've seen a couple people who don't really like that type of content, and if you don't, you know, I won't be mad at you if you ignore it. Not at all. Not in the slightest. It won't bother me one bit. And I won't be offended. And if you want to tell me you don't like it, that's cool too. Like, that's okay. I'll take it. I got a hate call. We're gonna get to Melinda Scott stuff in just a minute. We are. That's what we're doing today. Melinda Scott's documents against the Supreme Janny Jersh. That's today. And where are we? Yeah. There we go. We've got her response to the motion to dismiss today. That is the big thing. We're going to get to that, but I just want to, you know, I haven't gotten to talk to the YouTube live audience since New Year's, right? Because I didn't do a show last night. I was hanging out with the wife and kids. We had a very quiet, fun New Year's at home. We spent it together. I think it was the first time all of our kids stayed up until midnight. We paid dearly for that today. They were tired and crabby, but it was fun. But yeah, I am trying to just keep people informed of what's going on in the legal and political hybrid world. So I hope you guys enjoy the content, and I will keep making it. But again, I try and make it very short and low cost of entry. And if you miss it, you know, you're not going to miss anything, you know, dramatic. And this content on the live stream is going to stay this way. And it is a nice way to not be sitting here on the live streams talking about election stuff the whole time, because I know people are getting really tired of that. So, yeah, we get to delve into other stuff and make fun of people like Melinda. Oh wait, no, I'm on Melinda's side now. I got to take that back. I am pro Melinda. Screw Janny Jersh. That man, he better take it off the goddamn internet. He put me on blast on his Mad at the Internet show, and now I'm double mad at the internet. Now I'm double mad at the internet because of that. He said that my e-thought, he was making fun of me as an e-thought. And that makes me, I can't support him anymore. I am big mad. You're right, big mad. Can't believe it. Okay. At some point today, I'm also going to hit, YouTube has this new feature called Shorts, and they're videos that are under 1 minute. And one of my favorite people has been doing Shorts, and that is Legal Eagle. And the best thing about the shorts is I bet someone else isn't writing his script anymore. And so Legal Eagle has short videos, and he had one today about Section 230. And we're gonna have some transformative commentary about his short video on Section 230. Mark Bird, deal with what? And the final thing before we jump into chats and Melinda Scott is this. I got the first hate call I've gotten in a while. It's been a long time since I've gotten a hate call, but I got one today. Meow Day, yes, it's Milo's out of a cup. I got one today, just around 9:30 or so. What's 360 area code? Does anybody know? I mean, I could look it up. I answered it. I didn't get a message. I answered it. I wish it would have been a message. If I start getting some good hate call messages that are, like just pure hate calls, I may record them and play them for you guys. But that's Seattle. Okay, that makes sense. You'll understand why it makes sense. I was a little confused because it was past 9 o'clock when I got this call, but that would be 9 Central Time, so it's only 7 o'clock West Coast. The person on the phone sounded like they owed Mary Magdalene money. This person was ancient. But I have, when I said that the two audiences are different, the live stream audience here and the other audience, the reason I know that is because YouTube gives me demographic information, right? And in the last week, I find this fascinating. In the last week, over half of my views have come from people over the age of 55. And over half of that are people over 65. So when I say a vastly different audience, it is a vastly different audience because I know the demographic info on you guys as well. It's really 18 to 40 for the most part, for the overwhelming majority. Oh, and female viewership is way up as well. It's amazing. I love it. So I am looking forward to more people yelling at me, quoting the book of Daniel, saying that what I am doing is treason and sedition. It might have been Lynn Wood. I don't know. Except he's in Georgia, not Seattle. So, I don't know. And I'm like, I just made a video about something. Like, you need to go to jail. You're done. Like, oh, yeah. I can't wait. Oh. Anyway, it's a blast. It's a new Riot a Minute, and I am fully ready for 2021 maximum overgrift. It's coming. It's here. Have at it. By the way, feel free to watch my 2021 New Year, New Hope video for less doom pilling and a little bit of hopeful smilage. Little hopeful smilage. It'll be there. All right, let's do these chats and then let's jump into Melinda's documents here. Asshole says, did I really get Ty Beard to tell me fuck you? Life goal number 1 complete. You did. You did. It was beautiful. Life goal number 1 complete. Also, set your filing date a day earlier than it is due and let a middle school kid read over it for a day. Toss him $10. It'll increase your filings quality 87%. Perfect. Perfect. Sixth Floor Madness says, I'm not the first person to wonder about vampires drinking period blood. Assuming they do drink it, what about women with heavy flows? They use a coffee filter to catch the clumps. Or drink it all like boba tea, chewy and sticks to the teeth. What the hell was that? That was horrifying. Oh my god. RZEQDW says, my holidays went from Christmas miracle good to absolutely horrible in the span of the last week. 44th week of March 2020 is off to a horrible start, and I'm not feeling terribly optimistic for the future. Man, that sucks. What's going on, buddy? DM me. Talk to me. Superstitious Oblivious B says, congratulations, Nick, on reaching 100K subs before the year ended. Thank you. Thank you so much. I have to figure out a tangible goal for 2021. Maybe it's 200K subs. I don't know. Versi says, there's a fairly large Daily Wire Discus community that still exists. I don't know if you ever took part of comments on the Daily Wire before Discus was removed, but I've been linking your stuff there. I did not, but thank you. Thank you for doing that. Heel versus Babyface. Love you so much. Back at you, buddy. We need to paint. We need to paint something. And hang out and chat. I got to pop on Az's stream before English, British, colonial New Year's or whatever. And I was a very busy day. So I was only able to be on there for like 30 minutes, but I loved it. I always loved it. Or love being on his show. And so we need to do another stream very, very soon. Lane Kyrie says, hey, Nick, the haunted house from the other day there's an address there. I'm not going to read it. It won't let me put the Zillow link in the super chat. It was super cool. And if it was cheaper, we totally would have bought it. Someone sent me the link in like an email, and I took a look at it. It does look like a cool house. Like on the outside from the pictures, it looks kind of normal. But the house looked pretty nice. I heard it wasn't in the best shape. It might need some work done to it. But for some people, they like projects. So who knows? BK says, G'day Rackets. 12-hour stream. So the perfect length to do a collab with EFAP. Happy New Year to you and your family. Hoping this is actually 2021 and not 2020 New Game Plus, because F that. The Emperor protects. Cheers from 3/4 Nick. Hey, thank you. Thank you. Cheers back to you. I'm hoping 2021 is better too. Where's Broly? He's right there. He's right there. He's just off frame. Blaine says, I see graffiti man boob Broly has been dethroned. Rip. I am rethinking my background, and because I don't like the wall, I don't like the foam panel. What I really want, I wanted one a year, I think it was a year and a half ago. Lady Rackets found a place that did whiskey barrel staves, and they would do a wall in them, and they look so cool. I really want one. I don't know. They're sold out everywhere right now. So I got to find out if I can do it. If I can do it. But there are no law books on that shelf. These are Warhammer, the Solar War limited editions. That's what all these books are. Right here. These have all been up in my closet. On a shelf in my closet, but yeah. So I need to go. I need to like do them. I've been reading one of them, but I'm really slow because I've been, as you guys know, I've been busy working on a bunch of stuff. Koatam, did Josh make fun of the audio foam? This room is like bare walls except for where there are shelves of books. and it echoes a lot because behind the walls is metal and concrete. So it's a mess. It's very echoey. I've been told that I don't talk into my mic properly, but if I do, it takes up my whole face. So I don't know what to do about that. I don't know what to do about that. How do I fix that? Does this sound different? I don't know. Get the right kind of mic. Get a bigger face. We'll see. I am considering different mics because you know, my kids have been asking me for microphones for their own projects and stuff like that. And so you know, I'm always on the lookout for new stuff. It's a lot more clear. I'm supposed to talk, see, because it takes in the sound here on the side, right? Like I'm supposed to talk into that, and I'm actually talking over the top of it, which changes things. That's the problem I've got. But I don't know. I gotta add some. I gotta figure it out. Mics are the gateway drug to Twitch thottery. Oh, I'm already there. Okay. Bad Vibes says, question on standing. If the court says you have no standing because everyone was equally injured or would be, then wouldn't that apply to other constitutional questions in law? It applies to X group. You have no standing. Yeah, kind of. That's the problem people are having. It's like it's not really consistent. And it isn't. It isn't consistently applied. Oh, I'm not getting a headset. Headsets sound universally like garbage. Mithran Imris says, L. Lin has gone knucking futs. I thought that after his actions in the various lawsuits, dude has taken 25 steps off of a 12-step pier. Yeah, someone was telling me the other day they are concerned for Kyle Rittenhouse. You know, that case is kind of on the back burner. I don't know how much Lynn Wood is involved in the criminal defense of Kyle Rittenhouse. So we'll see. Dave Ramsey uses a headset? Well, then I will buy a headset and then crawl into a grave before I will do anything Dave Ramsey does. I'm just not a fan of that guy at all. Thedius says, please, using Kermit's voice, get ready, Miss Piggy, because I'll make your bacon squeal. Happy New Year, Nick. Hey, Happy New Year back to you, Thedius. Michael Tynan says, hey, Nick, let's make 2020 a most griftful year. Best of luck to you. Hey, best of luck back to you, Michael. Mr. Weasel LaFerret says, hi, I DM'd you about my brother's situation with his abusive wife on Twitter. Recently, my brother told me that his pics and videos of abuse he saved on Facebook is deleted, and now has that account on lock. I want to say thanks for listening. He may be able to petition Facebook to get those pictures down. I don't know the process of it. I mean, he could certainly subpoena them if there's a case about it. Asshole says, you need Ty on more. Seeing him get triggered off my chat and ranting for half an hour was euphoric. What other things would trigger him? I need advice for next time. Oh, just tell him that John Wayne was a pansy. That'd be enough, I think. Angle the top away from me. Oh, you're a genius. Does that work? Does it rotate? It doesn't rotate in that way. Oh, baby. Maybe that works. I don't know. We'll see. Okay. Okay. Let's check your email. There's an email from one of Melinda's John Does containing some inside info on her case. And I'd like to know if it's what? I love the check your email thing. I feel like I'm being hacked. My email server lately has been really, really slow. Okay, let's see. Let's get here we have Melinda Scott and her response to the motion to dismiss. I don't think there would be, I should check real quick and make sure there isn't anything new that was filed like today. In theory, things could have been filed. I don't think anything happened, but I want to make sure we have the oh my goodness, most up-to-date info. Oh, guys, I was watching Punisher Season 3. It occurred to me that Lady Rackets and I never finished Punisher Season 3. Okay, no, this is the most recent thing. Perfect. Perfect. We never finished the Punisher series. And it was the episode where he gets in a fight with Russians in a gym. And oh man, it was brutal. Okay. All right. So this is an email from one of the John Does in the lawsuit. And before anybody thinks of anything, it's from a Proton Mail throwaway account. So no, I don't have any information that would help you find out who this person is. Melinda, you weirdo. Even though I'm on your side now because Janny Jersh needs to be swept up. Let me see. I'm just skimming this real quick. oh, that's funny. Yeah. Let's see. Wow. Hold on, I'm reading through this real quick. I know this is weird for you guys, but she trying to get you into a contract? Okay, wait a minute. What's going on here? She trying to get you into a contract to disclose information about kiwi farmers, and then she will retract her accusations about you threatening to kill her? I know you guys can't see it. It's cuz I don't know how much of the email I should show. Oh, that's beautiful. That is beautiful. Yeah, if you're new here, sometimes there's weird stuff. Okay, we're gonna go. Yeah, Breck. For real. That's called extortion. It's pretty close. It's pretty close to extortion. She shouldn't do it. She could maybe construe it as a settlement a settlement offer. But yeah, not recommended. Not recommended. Okay. You know who tried that? I don't know if you guys know Michael Avenatti. He tried that too. All right, go to the nearest beach and check the message in a bottle I left you. I'll be right back, guys. Kidding. And one final note as we dive into this. Where is Josh? Some people were confused because I said that Josh wasn't going to be on this show. What I meant was Josh was not going to be on the show that I was doing at the time, and nor will I have Josh on to talk about Melinda Scott during the pendency of the case. I'm happy to have him on to talk about anything else. I love talking to Josh. Plus, I need to cry at him about making fun of me. And then I'm happy to have him come on to talk about this case when it's over. But I don't want him to say anything on a show that could be clipped out and misconstrued by Melinda, who seems to have a habit of misconstruing things that would complicate his case with the court. I don't want anything like that. There's no reason to cost him any more money other than his mean bigotry towards me and my beautiful transformation into an e-thought. Okay. Hat Buckles, there's no way Pence resigned. No way. 2021 can't be that funny. Can't be that funny. I refuse to believe it. By the way, how you doing, Hat Buckles? Been a while. Long time no see, buddy. Been a long time since Chicago. Okay. Plaintiff's response to defendant's motion to dismiss. We're going to do this a traditional way. We're going to read through her entire paper. We're going to read through the entire paper and see what she's got. Entry of default's effect on motion to dismiss. Defendant's Rule 12 motion to dismiss barred by entry of default in court order. This whole section will be mooted if they get the default entry overturned, and there's a high likelihood of having the default entry overturned. This court issued an order stating that the defendant was not able to bring a defense. In the order, it was stated the defendant's time to respond had expired. Periods outside the quotes. I don't like it. Defendant by counsel bring his motion to dismiss under Rule 12. Defendant's motion to dismiss is improperly filed before this court because it is a defense to the complaint after the 21-day time period allowed for a response. Let's see. Go ahead and pull this up. Let's just check her reading of the rule without prejudice as to what it may be. Let's see. Defenses and objections, when and how presented, motion for judgment on the pleadings, consolidated motions, waiving defenses, pretrial hearing. So 12B tends to be the motion to dismiss rules, and so we'll take a look at those. But here is Rule 12A. Time to serve a responsive pleading. In general, unless another time is specified by this rule or a federal statute, time for serving responsive pleading is as follows. Defendant must serve an answer within 21 days after being served with the summons and complaint. Now, of course, Josh's defense to all of this is that he was never served with the summons and complaint, that the rules of the forum state of Virginia, as well as the rule, it's Virginia, right? Is it? Yeah, Virginia. The rules of the forum state of Virginia, as well as the rules of the non-forum state of Florida, where service was purportedly done, were not followed. And similarly, that Josh is not in the United States and must be served according to the rules of service wherever he is, like Ukraine or something. So he was not served, so his 21 days can't actually have expired. If it is timely waived service under Rule, if it has timely raised service under Rule 4D within 60 days after the request for waiver was sent, or within 90 days after it was sent to the defendant outside any judicial district of the United States. So here's another problem. Even if Oh, wait, no, that's only for waiver of service. So he didn't waive the service. A party must serve an answer to a counterclaim or cross-claim within 21 days of being served. Okay, so 21 days for the answer or cross answers. The answer, the responsive pleading. So let's go ahead and do 12B. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required, but a party may assert the following defenses by motion. Notice, responsive pleading as follows. How to present defenses by motion. So these are not a responsive pleading. So, effective a motion, unless the court sets a different time, serving a motion under this rule alters these periods as follows. If the court denies the motion or postpones its disposition until trial, the responsive pleading must be served within 14 days after the notice of court's action. Or if the court grants a motion for a more definite statement, the responsive pleading must be served within 14 days after the more definite statement is served. So that doesn't really follow here. So these can be given by motion. I wonder if we have a timeline on a motion. Lack of subject matter jurisdiction, personal jurisdiction, venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted, and failure to join a party are the reasons, the 12B reasons. A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. If a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert at trial any defense to that claim. No defense or objection is waived by joining it with one or more other defenses or objections in a responsive pleading or in a motion. Motion for judgment on the pleadings. Result of presenting matters outside the pleadings. If on a motion under Rule 12b-6 or 12c, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under 56. All parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. Let's see. Do we have any time? Nope. So there's no timeliness on motions in Rule 12. There's only timeliness on serving a responsive pleading. That is 12A, but we are on 12B. I think she's misreading the rule here. I don't see any cites to case law to support her assertion that his motion to dismiss is a responsive pleading or that it is time barred. Idea Machine says, grats on 10 to the 5th power subs. Watch out, mundane fat. Bad Vibe says, wait, Josh is making fun of you. Must be out of lolcows. I mean, it isn't like you don't have the largest hate following of a non-celebrity. No. It was all in, I don't know if it was all in good fun. Okay. Defendant's motion to dismiss is improperly filed before this court because it is a defense to the complaint after the 21-day time period allowed for response. I don't think it is. I mean, an answer is the responsive pleading. But a motion to dismiss. Let's see, what do we have? Do we have a timeline for motions? This is like Federal Rules of Civil Procedure. I haven't read up on the 12b-6 motions because usually you just file your 12b-6 right away rather than, having to deal with dismissing a default judgment. So it's not something I deal with all the time. It's not something you even read about that often. Okay, so Rule 12 permits a Rule 12 defense to be brought when a responsive pleading is allowed. Rule 12 states that a motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. But he has made them before pleading, right? Because he hasn't answered. So, okay. The Marshallist, you don't have to pay $20 for me to read something. It's just, that's the easiest way to make sure I read something. Let's see. This court already ordered that a responsive pleading was not allowed. Defendant by counsel does not present his potentially meritorious defenses under Rule 55C. So this is really interesting. So I don't think she realizes that if a responsive pleading is not allowed, then the motion doesn't have to be made within the timeline. Like just by a plain reading of the text. A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. Well, if it's not allowed, then it can't be made before the pleading. That doesn't mean that it disallows the motion. So this is terrible reasoning by Melinda Scott. Defendant's motion to dismiss is irrelevant. Wait, what's Rule 55C real quick? Let's just see. This default judgment. Oh, yeah. The court may set aside an entry of default for good cause, and it may set aside final default judgment under Rule 60B. Of course, there is good cause. He wasn't served. Very simple good cause. Defendant's motion to dismiss irrelevant without a valid reason for lapsing into default. Defendant Moon was properly served the summons and complaint pursuant to Rule 4E1 at his business address in Florida. Let's just do this. Melinda. 4 is Rule 4 summons, okay? E, serving an individual within a judicial district of the United States. He's not within a judicial district of the United States. Even if his business is, he's not. Unless federal law provides otherwise, an individual other than a minor, an incompetent person, or a person whose waiver has been filed may be served in a judicial district of the United States by E1, following state law for serving a summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is made. So that would be in Florida. Okay? Let's check this out. Florida Rules Civil Procedure Service of Process. This is the fun part of law, is like you have to do this. All right. So made in Florida. Service by whom made. Service of process may be made by an officer authorized by law to serve process, but the court may appoint blah, 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 blah. Let's see. Numerous defendants. Service by publication. May be made as provided by statute. Copies of initial pleading and person served. Service of orders. Service of process by mail. A defendant may accept service of process by mail. Acceptance of service of a complaint by mail does not thereby waive any objection to the venue or to the jurisdiction of the court over the person of the defendant. Plaintiff may notify any defendant of the commencement of the action and request that the defendant waive service of summons. The notice and request shall blah, blah, blah. If a defendant fails to comply with a request for waiver within the time period herein, court shall impose the costs. A defendant who, before being served with process, timely returns a waiver. Time limit. Okay. It doesn't say where they can receive. Let's see. Oh, I hate. Let's see. Service. So process. Service and filings of pleadings. Every pleading subsequent to the initial pleading, all orders and other document filed in the action must be served. That's subsequent to the initial pleading. Where is... God, I hate Florida. I'm trying to find out where you can serve it. Let's see. Person serving process shall make proof of service by affidavit promptly and in any event in the time. It doesn't say how to serve. There's more than one defendant, clerk, or judge shall issue as many writs. Service of process may be made as provided by statute. Copies of initial pleading for persons served. Service of orders. Let's see. It says it can be accepted by mail, but he didn't actually accept it by mail. Okay. Well, I'm not entirely sure. I mean, that's the rule. There must be a separate statute for where service is made. But I don't want to sit and dwell on it. But either way, typically you can't serve someone at a business address. Like that's where you would serve the entity, not where you would serve the person. So she served it to a place that allegedly forwards mail that he can then pay to receive. That's not service. But here's the problem. He's not in the United States. He's outside the judicial district of the United States. So these rules don't actually apply to him. Here is what she would need to follow. F is what she gets on this grade. Serving an individual in a foreign country. Unless federal law provides otherwise, an individual, other than a minor, an incompetent person, or a person whose waiver has been filed, may be served at a place not within any judicial district of the United States by any internationally agreed means of service that is reasonably calculated to give notice, such as those authorized by the Hague Convention on the service abroad of judicial and extrajudicial documents. There's no internationally agreed means, or if an international agreement allows but does not specify other means, by a method that is reasonably calculated to give notice, as prescribed by the foreign country's law for service in that country, in an action in its courts of general jurisdiction, as the foreign authority directs in response to a letter rogatory or a letter of request, or, unless prohibited by the foreign country, by delivering a copy of the summons and the complaint to the individual personally, or using any form of mail that the clerk addresses and sends to the individual and that requires a signed receipt, or by other means not prohibited by international agreement as the court orders. None of that happened at all. None of that happened at all. Okay. Let's see. This will be interesting. Let's read her footnote. Defendant Moon has always held himself out to be an LLC. Nope. Defendant Moon literally cannot be an LLC. Defendant Moon is a person, Melinda. An LLC is a business entity. It is a separate legal creation. It is something wholly different from Defendant Moon. You have not pierced the corporate veil, nor would you on service. You did not sue the Kiwi Farms. You sued Janny Jersh. So he is not an LLC. Never has he held himself out to be an LLC. That would be impossible. He was formally registered in 2016 in Florida as the business Lolcow LLC. No, he was not. He had a business that he owned, Lolcow LLC. Florida statute requires any LLC to have a registered agent. He did not renew his registration after the plaintiff filed a suit against him in 2018 in order to avoid service and act as an evasive defendant. You can't actually state that that's conclusory. However, on his website, he labels his business Lolcow LLC. On March 17, 2019, Joshua Moon published on Kiwi Farms the following statement. My company is contained within a Florida company. If you need an address to send physical documents to this works. Lolcow LLC, yada, 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 Fort Walton Beach, Florida. But again, that's to send to Lolcow LLC, not to Josh Moon. That is not service of Joshua Moon. As a sole proprietor, business owner, he is one and the same as Lolcow LLC. No, actually, if Lolcow LLC was an entity that was dissolved in 2018, you can still serve that entity because it's still within the statute of limitations. But if you're serving him, you have to serve him at his address. Defendant requests relief. According to... Oh, here we go. According to Virginia Code, Florida Statute 48062. Okay, let's do this. Florida Statute 48-062. Oh, I can already see why this is wrong. Service on a limited liability company. Melinda! He's not a limited liability company. You're making the argument that he's not a limited liability company, and then you're citing the rule for serving a limited liability company, but you're not suing the limited liability company. All right, the Fiend, I'll think about it. Okay, let's see what she should have cited, since this isn't an LLC. Service on generally. Here we go. Service of original process is made by delivering a copy of it to the person to be served with a copy of the complaint, petition, or other initial pleading or paper, or by leaving the copies at his or her usual place of abode with any person residing therein who is 15 years of age or older, and informing the person of their contents. Minors who are or have been married shall be served as provided in this section. Okay. That didn't happen. I don't think Josh lives at, like, the post office place or whatever. An employer, when contacted by an individual authorized to serve process, shall allow the authorized individual to serve an employee in a private area designated by the employer. That is, of course, not true. Substitute service may be made on the spouse of the person to be served at any place in the county if the cause of action is not an adversary proceeding between the spouse and the person to be served. Okay, so that doesn't matter. Substitute service may be made on an individual doing business as a sole proprietorship at his or her place of business during regular business hours by serving the person in charge of the business at the time of service if two attempts to serve the owner have been made at the place of business. So clearly, even if she's right that he is a sole proprietor, she still didn't follow the rule. Still didn't follow the rule. The next is about witness subpoenas. So not proper. So good job, Melinda. F again. You've cited the wrong section of the Florida statute, and you've gotten it incorrect in general, and it's contradictory to your own argument in your own footnote. You don't have to be a lawyer to realize that this is embarrassing. Defendant requests relief from the entry of default judgment under Rule 55C within his motion to set aside default. In defendant's motion to set aside default, defendant claims surprise as a reason for requesting the default to be set aside. Defendant, by counsel, claims to have received first notice of the lawsuit within the default order on November 23rd, 2020. Yep, that makes sense. Alongside the motion to dismiss. However, defendant is lacking the other required components to qualify for granting a motion to set aside default. The standards set by the legal standards of the Fourth Circuit require a valid reason explaining why the party fell into default. Namely, the defendant must show an acceptable excuse for lapsing into default. He wasn't served! Which is a standard set forth in case law the plaintiff presents here in her accompanying memorandum. Defendant claims, contrary to the marshal's proof of service, that he did not receive the summons and complaint, yet has provided no storyline whatsoever about how the summons and complaint disappeared into thin air. Come on. Melinda! Why? Yellow Flash 2, hey, what's up, man? How is Face Off? He says, congrats on hitting 100K. Make sure to cry when you get your play button. I'll sit in a bathtub full of my own tears in a bikini. I'm joking. Before anyone takes that seriously. Without an acceptable excuse for how defendant did not get the summons and complaint from his designated staff and employees. Listen to this. Footnoted it. The quick pack and ship employee designated by defendant Moon to receive his mail, as well as the unnamed third party in the proof of service. I'm pretty sure Josh Moon did not authorize specifically the quick pack and ship employee to accept service on his behalf. I'm guessing that didn't happen. The meritorious defense components within defendant's motion to dismiss is irrelevant under the legal standards of the Fourth Circuit presented by plaintiff in her accompanying memorandum. Meritorious defense is not sufficient in and of itself to set aside a default entry. Upon testing the sufficiency of the motion to set aside default, the defendant has not met all of the other components necessary to relieve him of the default entered. You should just have this in your argument section. The defendant has to demonstrate all 5 of the requirements to set aside default. A possible meritorious defense. Well, yes, this is entirely frivolous and completely stupid. Melinda, are you watching today? Melinda, are you out there? If you are, please just say hi in the chat. I mean, I'm going to just keep making fun of you, but, you know, go ahead and say hi. That would be great. 2, promptness of the defaulting party, which typically the rule suggests a year as being kind of standard. The personal responsibility of the defaulting party, none. There's no personal responsibility in not being served. The prejudice to the other party, none. If they didn't serve them, there's no prejudice. And 5, whether there's a history of dilatory action. If you haven't been served, you can't have a history of dilatory action. As of this date, Defendant Moon has given no justifiable reason the people designated to receive and hold his mail, the employee of the quick pack and ship, and the unnamed third party, did not hand over the summons and complaint to him. They're not authorized to accept service. Here's the crazy thing. Even if the quick pack and ship people received the service and gave it directly to Josh, that's not service. That's still not service of process. You can't just because someone happens to get a copy of their lawsuit doesn't mean they've been served. Service has to be done in a very specific way, defined by statute and rule of civil procedure in the federal system or in the state system, depending on where you are. Florida has clearly laid out how you get service, and none of them is what was provided. So let's say Josh was in the back of the quick pack and ship, watching my thought stream, fapping, and sweating and everything. As we know, that was probably going on when they were delivered the service. Okay. And she hands it to the employee, and then, or the marshal hands it to the employee, and the marshal leaves. And then Josh comes out, feeling very refreshed, wiping his hands off on a towel, and the quick pack and ship employee hands him the envelope right there, 1 second after the marshal leaves, and hands it to him. He has not been served. He has not been served. That is not service of process. That is not adequate. He can admit to all of that. He can admit he was there. Personal service is personal service. Now, if he lived at the quick pack and ship, like if he lived there, if that was his place of abode, different story. Don't think he does. All right. As of this date, Defendant Moon has given no justifiable reason the people designated to receive and hold his mail did not hand over the summons and complaint to him. This component alone is enough to deny the motion to set aside default. In addition, defendant cannot demonstrate he had a valid reason or excusable neglect under Rule 60B for being relieved of the entry of the default order. I mean, yeah, yes, he does. Oh, God. Defendant's motion to dismiss is inadequate to dismiss plaintiff's complaint. Okay, so we're going to get to the merits now, I guess. Whew. Notwithstanding. Even if this... What? Notwithstanding. Okay. That's a weird opening to then follow with, even if this court would set aside the entry of default and allow the motion to dismiss to be ruled upon, the following are the reasons defendant motion to dismiss should be denied. So number 5, defendant presents the motion to dismiss as a meritorious defense. component seeking to set aside the entry of default simultaneously with defendant's motion to set aside default. Yeah, that's okay. You can combine motions. It's literally in Rule 12. Melinda, read the rules. Buy a book on the rules and read it. Ask me. Send me postage and I'll mail you my civil procedure book. Go ahead. Socialism is for figs. Says, my prison mate who read up on law got me off of interspecies erotica. He doesn't have a degree, just a prison cell and a very tiny pencil. Oh, and not even a legal pad, just toilet paper. Okay. Asshole says, is there a way to get Discord access without subscribing to a monthly BS shit? I toss a lot of money I probably shouldn't around to a lot of people, but committing to a monthly anything is not a thing that I do. I currently don't have anything non-monthly to get into my Discord. I just don't have it. My Discord admin does a ton of work already maintaining, people's roles and making sure the Discord actually functions. And I can't find some other way to do it and keep track of it for him. I don't know. But what you can do is if you sign up for the monthly thing, you could just cancel at any time, right? Like just like any other grifting business. You're just able to cancel. Like put it on get a Visa gift card or whatever, and then just if you ever don't want to give the $5, just don't renew it and it'll cancel. Fine by me. Okay. So, here we go. Following are the reasons defendant's motion to dismiss should be denied. Service of the summons and complaint was valid. Plaintiff properly served the defendant according to the reasons that follow. The summons and complaint were served within the time limit allowed. The complaint was filed July 8th, 2020. Defendant was served by U.S. Marshal on August 18th, 2020. Rule 4E was followed. The state laws and statutes of Virginia and Florida were followed. Plaintiff Scott stated in her complaint that Defendant Moon is a business owner of the website KiwiFarms.net. He runs KiwiFarms.net under the name Lolcow LLC as a business owner. Mr. Moon is the sole owner of the business, and no other business owner was named in the complaint. As a sole proprietor, he is one of the same as Lolcow LLC. Defendant Joshua Moon can be served as an LLC. Nope. That is not true in any stretch. Even assuming everything she said was factually accurate, that is not true at all. No, you can't do it. Defendant Moon has always held himself out to be an LLC. He was formerly... This is the same footnote, Melinda. You just copied and pasted it. Don't do that. Put the footnote 6 and say see footnote 3 or whatever. Whatever it was. God. Ugh. It's also wrong. Under Virginia law, an LLC business can be served according to Virginia Code 801299. The address Defendant Moon publishes on his website is a business address. As noted in the delivery of summons by the marshal, it is his electronic mailbox with a third-party officer whom Mr. Moon has designated to receive his mail for him and bring it to him as a business owner. Let's see Virginia Code 8.01299. Virginia Code 8.01-299. Just real quick. Virginia law doesn't really apply here, but by personal service on any officer, director, or registered agent of such corporation or on the registered agent of such limited liability company. Is the employee at the quick pack and say ship the registered agent? I don't think so. I don't think that's the registered agent. That's just an employee at the quick pack and ship. I don't know if quick pack and ship actually does registered agency. Let's see. Florida business lookup. Florida Secretary State Business Entities. That's what we're looking for. Okay. Let's search by names. Lolcow. Search. Lolcow LLC. It is inactive. All right. Administrative dissolution for annual report on 2017. The registered agent name and address is Agents and Corporations, Inc. in Naples, Florida. Authorized person detail, Joshua Moon. So, there is a registered agent on file. I mean, it's an inactive LLC, but there's a registered agent. I think you could actually argue that serving that registered agent would be effective service. If you were suing the LLC, which you're not. Let's see if there's a Kiwi Farms. Kiwi. Holy hell, there's a lot of things that start with Kiwi. Try Kiwi Farm. Kiwi Farms LLC. That's a completely different person. That's Michael Gross. Who's that? Administratively disillusioned or dissolved in September 25th of 2020. Oh, wait. Michael Gross is a registered agent. This might be it. Manager. But again, you could... Actually, at the time she filed this, this was... I don't know if Kiwi Farms LLC is the actual thing. I know you guys can't see it because it's got addresses on it and names, and it might not be, you know, that might not be Josh Moon. So someone could have also just registered that LLC, like to fuck up with Josh. I don't know. So anyway, very, very weird. But again, if you're trying, but she's not suing the LLC at all. Okay. The address Defendant Moon publishes on his website is a business address. Oh, I read that. This is also a valid service under Florida law. An LLC is required to have a registered agent. Defendant Moon does not have a registered agent. Florida law provides that if service cannot be made on a registered agent of the limited liability company because of failure to comply with Chapter 605, or because the limited liability company does not have a registered agent, or if its registered agent cannot be, with reasonable diligence, be served, process against the limited liability company, domestic or foreign, may be served on a manager or a manager of a manager-managed limited liability company. Okay, you didn't serve a manager. Or if a member or manager is not available during regular business hours to accept service on behalf of the limited liability company, he, she, or it may designate an employee of the LLC to accept such service. After one attempt to serve a member, manager, or designated employee has been made, process may be served on the person in charge of the LLC during regular business hours. None of that happened, Melinda. Melinda, come on. The Quick Pack and Ship is not an employee of Joshua Moon or Lolcow LLC. And Lolcow LLC is not who you're suing. Socialism is for Fig says, oh, and by the way, I will leave it up to you how I had to pay my prison mate back. It was very unpleasant. Well, I think it went up to you. Defendant Moon was not only on active notice that he had been served a summons and complaint, he was also on constructive notice. There's not constructive notice of service of process. It's not a thing. Through his own website, kiwifarms.net, that the lawsuit was forthcoming. All right, the accompanying case law presented in the memorandum demonstrates why constructive notice is enough to require defendant to respond to a lawsuit. Rules of civil procedure allow summons to be amended through Rule 4A2. A minor technical oversight of omitting the exact district court name on the summons is insufficient to dismiss a case with prejudice. No, it's the frivolous nature of the case that is sufficient. Jurisdiction, venue, and aggregated claims. Cases being filed in this case being filed in this court meets all requirements for proper venue and jurisdiction. Aggregated claims represent requirements set by law have also been met. Aggregated amounts. Jane Doe, John Does are still defendants in this case, as plaintiff has made diligent efforts to locate IP addresses to serve them. They have not been dismissed as defendants. Oh, wait, we've got some, I missed some footnotes. In addition, the summons was marked with the marshal's stamp of Roanoke and the civil case docket number. Complaint had Western District of Virginia and a stamp of Abingdon Division. Defendant Moon could have conferred with plaintiff regarding the name of the courthouse. It's a form requirement, sweetie. You can't just say he could have done this. It's not true that he wouldn't know where to file. No. In law, everybody is room temperature IQ. If you don't tell them what to do, they're under no obligation to find out what to do. Like, you have to, that's why you have to tell them, that's why there's a form requirement laid out in statute. You have to tell them these things. That's why you have to have the courthouse on there, because they don't have to find out what courthouse you sued him in. You have to tell them. When there is actual notice, every technical violation of the rule or failure of strict compliance may not invalidate the service. We saw this argument earlier. There wasn't actual notice. Plaintiff has also made diligent attempts to garner their address for service of a summons and complaint under the legal standard of the Fourth Circuit as briefed in the accompanying memorandum. Plaintiff qualifies for an extension of time due to her diligent efforts, pro se status, and her status as a litigant proceeding in form of Pop Harris. Combined totals of similar claims against similar defendants of all John Does and Jane Doe combined with all claims against Joshua Moon meet the amount and controversy standards required by law. Jurisdiction. Court has jurisdiction over Joshua Moon pursuant to Virginia state law. Plaintiff is a resident who has resided in Southwest Virginia since 2016. Defendant Moon caused her a tortious injury by a willful act which started in 2017 and has continued to the present time. That's not sufficient jurisdictional argument. Not that they should bother with the jurisdictional argument at this point, because it should just be dismissed anyways. James Valdez says, take my renminbi. Vulcan still lives and all is dust. M. Burr. Vulcan lives. Josh Moon has significant ties to Florida. Namely, he's a registered Republican with a reported active status which requires a domicile in the state of Florida. You're not in Florida, Melinda! You're in Virginia. You're in Virginia, not Florida. His ties to Florida aren't helpful to you. They're actually harmful. Joshua Moon's mother's residence is in Pensacola, Florida. His mother's home is Defendant Moon's residence as well. I mean, is it? Does he live there? Is he there? Joshua Moon has significant business presence in Florida. Why are you talking about Florida? You're not suing. You don't have the venue in Florida. You have the venue in Virginia. I'm gonna get cancer from this filing. Joshua Moon's claim to be a resident of the EU has not been supported by any evidence. As stated in the accompanying memorandum of law, the standard of the Fourth Circuit is to provide more than just denials and conclusory statements. Conclusionary. The hell is a conclusionary statement? Constitutional violations alleged in the complaint against Joshua Moon, in which he acted as a state actor, are included in the complaint. He can't be a state actor. What is this? It doesn't say conclusory. It says conclusionary. Guys, Josh Moon is now the government. By the way, Oh, I showed this on Twitch, but I haven't showed it here. Rick Nikita sent me a bottle of Whistle Pig, and he said, "Thanks for not killing yourself." It is an 18-year Whistle Pig. I've never seen this before. Rick Nikita may have been present when the bottle of Boss Hog hit the floor. I showed it here? Oh, okay, good. God, I don't even remember anything anymore. Okay. Venue. Joshua Moon forwarded and distributed content from his business website to the employee emails of Wise County Department of Social Services. Did he actually do that? This action reached into Wise County, Virginia to contribute to Ms. Scott's claim of constitutional violations and IIED against multiple defendants, including Defendant Moon. I don't know if he did this or not, so I'll take it as true for the purposes of reading. Constitutional violations alleged in the complaint against Joshua Moon were a course of conduct through intentional acts done by Defendant Moon while engaging with Wise County Department of Social Services. Joshua Moon's actions reached into Wise County, Virginia to contribute to Ms. Scott's claim of constitutional violations and IIED. Joshua is not a state actor. So he cannot do a constitutional violation. He can't. He's not a state actor. If he reached into Wise County to mess with Melinda, it's possible that that could give rise to jurisdiction over him, and this being the proper venue. If he did that, it might be possible. However, typically, you can't be held liable for reporting something so long as it's not an overt lie to a government agent. Like, public policy would dictate that we don't want to chill people reporting actual abuse of children to human services or social services, for example. So sending them information about a potentially abused child wouldn't be illegal unless you knew, like you could demonstrate malice, actual knowledge of the falsehood in the statement. But as far as I know, she's not actually suing him for defamation. Just intentional infliction of emotional distress, which you can't do by making a report to a government agent. Court has venue over Joshua Moon. No, Melinda. The court is the proper venue. It has jurisdiction over Joshua Moon, because he targeted the social harm and social abuse alleged in the complaint toward the plaintiff in her neighborhood, local area, local county, and state of residence as well, Wise County, Virginia. Court has venue. The court is the proper venue. The court doesn't have venue here because Joshua Moon targeted an audience to inflict social harm on the plaintiff within bordering states that comprise the Fourth Circuit. No, that's not how that works. That's not at all how that works. Plaintiff has more than adequately stated in her complaint the series of events that led to the Joshua Moon contributing to a malicious phone call were made to a child welfare agency in Wise County. Joshua Moon contributing to a malicious phone call. Was he on the phone? The hell does that even mean? Constitutional violations as a state actor by Defendant Moon. This is a messy document, guys. This is a messy document. Joshua Moon is a state actor for constitutional violations. Joshua Moon acted as a state actor in funneling information from his website directly to Wise County Social Service employee emails, outside the normal standard of communication, using telephone calls from anonymous reporters who call or report alleged child abuse and neglect. Reports do not have to be anonymous. They can come in all sorts of ways. Oh my God. Constitutional violation claims against Joshua Moon are listed under 5th and 14th Amendment sections of Cause of Action 1. Plaintiff also adequately stated that Joshua Moon's website distributes court documents, a function normally reserved for government agencies. Nope. That is not. No. That definitely no. No. That's not. That's definitely wrong. That's wrong. Definitely wrong. The accompanying memorandum sets forth the ways in which Defendant Moon has acted as a state actor. Wrong. Jason Poofes, I saw that. Lynn Wood is going to take her case? Yes. Yes, do it. Oh, God. Defendant's Rule 12b6 claims. Plaintiff has properly pled a claim for which relief can be granted. Nope. Court ruled that after a review of the record, she qualified for a default. You're not even arguing the right thing here, Melinda. She's adequately pled all facts and elements required of the tort IAD under cause of action 2 in her complaint. No, you didn't. Plaintiff Scott adequately described Mr. Moon's involvement as a defendant in paragraph 66 through 80. Plaintiff Scott has stated that Moon's conduct was over the course of 3 years. Plaintiff Scott stated that Joshua Moon's behavior was extreme, outrageous, and indecent. Plaintiff adequately stated in her complaint that Joshua Moon was responsible for intentionally inflicting emotional distress through orchestrating and encouraging social abuse aimed at the plaintiff. Plaintiff adequately stated that Moon's course of conduct against Plaintiff Scott was to injure her. Adequately stated that Defendant Moon encourages other KiwiFarms.net users and true and honest fans. That's the tag, true and honest fan, of his website to be malicious towards the plaintiff. Plaintiff adequately stated in her complaint that Joshua Moon was responsible for causing the plaintiff emotional distress through orchestrating and encouraging social harm through the content of his website. Plaintiff adequately stated that Joshua Moon, as a result of his actions described between paragraphs 66 through 80, caused her extreme emotional distress, including anger and rage. Anger and rage aren't extreme emotional distress. Did you go to a doctor? Did you have to go to a doctor? Did you miss work? Ever? Once? Did you once miss work? Do you work? Chronological and interwoven connection between Defendant Moon, his website users, and his true and honest fans was adequately described in plaintiff's complaint in paragraph 66 through 80 of the complaint. Joshua Moon is responsible in part for the conduct of others who are his website users and true and honest fans of his site because he is creating, developing, editing, encouraging, and orchestrating the entire operation as a business owner because he encourages other users to scapegoat and injure the plaintiff. It's all stated in plaintiff's complaint. That's a shit theory. This court already ordered that after a review of the record, including the complaint, the plaintiff was entitled to entry of default. The review of the record was service made, which you just lied about adequate service being made. To be fair, you probably didn't lie because you just don't understand the rules of service, and that happened to get past the judge. That's all. Because the judge doesn't know anything about Joshua Moon. You had to misrepresent that he was actually in Florida. It was handed to an employee of his business and stuff like that. When you did that and the judge just believed you, that's where you got the default judgment. It's not like he reviewed the claims and said that they have merit. He reviewed the claims and says, if this person doesn't care to respond, then I don't give a shit to help them. Cyberbullying as a true threat. Posting someone's residential address for an intentional international audience in order to put someone under surveillance with the purpose to intimidate, harass, or threaten is in fact a real threat to a person's body and their personal property. Nope, it's not. It's really not. A threat is a separate act than a dox. That's a completely different. Although the online users of KiwiFarms.net pulled the plaintiff's county of residence from government databases, these databases are not available to the general public. Yes, they are. That's why they're government databases. Pacer's available to literally anybody. They are members of the general public. How do you think they got them? In order to access the information on Pacer, user must create a profile that is screened and authorized to use the database. No. No, honey, no. Users must input their name, address, and social security number in order to have access to the documents. Heavy screening right there. Are you exist? Purpose of the documents available in the PACER system is to inform the public. Melinda, I thought they weren't available to the public. Make up your mind! Oh, God. Taking those documents and redistributing them online for an international audience in order to intimidate, harass, and threaten the plaintiff is an indecent use of court information. If their purpose is to inform the public, how are you going to argue that making them available to the public is somehow harmful? Doesn't make any sense, woman. Mithrin Emrys says, I can forgive a lot from a pro se, non-lawyer plaintiff. This shows a lack of basic reading comprehension, let alone basic legal knowledge. So many contradictions. All right, we'll have a great section on 230 immunity. CDA section 230 immunity does not apply to Defendant Moon. Okay. Plaintiff adequately stated the reasons in the complaint why Joshua Moon does not qualify for immunity under CDA section 230. Oh, I don't have that handy. Plaintiff has attached a memorandum with relevant case law demonstrating why he does not qualify. Oh, I'm sure that is brilliant. I hope we'll get there in just a minute. Other matters. Tort of IIED is a federal claim. Is also a federal claim in the second restatement, section 46. I mean, that's not how that works. Linda, that's not what that is. The restatements of law, they have restatements of torts, restatement of contracts, restatement of states, restatements of everything, are a book compiled by lawyers. Like a bunch of lawyers work really hard on the restatement, and they go through the case law that has happened since the last restatement. They try and do is put into the best available present language the common law. So IIED is intentional infliction of emotional distress. So in the second restatement of torts, for example, there's a third restatement of torts, by the way. The second restatement of torts, there will be a claim for international or intentional infliction of emotional distress, and they will define in language, updated language, the best definition they can come to over what a claim for IIED looks like. And then a state has to adopt the restatement explicitly. I don't know that the federal court has adopted an IIED claim because it would just be a state law claim. You would have to argue that Virginia has adopted the second restatement's definition of IIED, but you don't need to do that. It's a Virginia claim. You're bringing it in federal court based on the diversity of the parties. Not because this is a federal question. State law determines the statute of limitations. That's because IIED is a state law claim. State law can't determine a statute of limitations over a federal crime. There's a federal statute of limitations or a federal cause of action. And Plaintiff Scott's claim of IIED falls within the time frame addressing Defendant Moon's course of action, 2018 to the date of filing of the complaint, July 8th, 2020. Okay. Doctrines of res judicata. It's res judicata, not res adjudicata, and collateral estoppel. Case is not prohibited by the doctrine of res judicata because plaintiff has res judicata means already judged, already justiced. Plaintiff has included new facts and new details in her 2020 complaint. Even if elements of prior cases were incorporated into this case, the prior cases were dismissed without prejudice. This case is not prohibited by the doctrine of collateral estoppel because this is the first IIED claim the plaintiff has ever brought against Joshua Moon. Plaintiff Scott previously filed appropriation claims, torts of defamation, invasion of privacy, and false light against Joshua Moon. Even if elements of... Just... Collateral estoppel is issue preclusion. And it's actually likely that this is a precluded issue if it's based on the similar set of facts as a previously litigated issue. Like renaming the issue. Like if I sue you for defamation and I lose, and then I come back and sue you for tortious interference under the same statements that you made, I should have sued you for defamation and tortious interference at the same time. It's the same set of information. So the claim would be precluded, or well, the issue would be precluded. Claim preclusion is different than issue preclusion. Claim preclusion is you sued for defamation. You should have incorporated more facts into your defamation claim as they support the same defamatory act. Like I lost on this defamation claim, and then I go back and I find new evidence for the same claim. And then I try to bring it again. That's claim preclusion. Issue preclusion is the whole issue. So, yeah, actually saying that you sued him for all these things, that actually is collateral estoppel. The suit was filed on July 8th, 2020 under an IIED claim, which has a 2-year statute of limitations, backdated to July 9th, 2018. The other cases against Joshua Moon were filed in 2018 for actions prior. Now, see, that is finally the first good argument in the whole thing. Information regarding plaintiff's other lawsuits and defendant's motion to dismiss. Defendant by counsel also includes information regarding plaintiff's other lawsuits within his motion to dismiss. Defendant by counsel failed to include all facts regarding lawsuits plaintiff has filed against defendant Moon and other third parties. Defendant's counsel seeks to create a false narrative about plaintiff Scott's filing history. Plaintiff's defense to these allegations, attempting to put plaintiff in a derogatory light, are responded to in plaintiff's motion to strike. Plaintiff's reply to second memorandum. Defendant by counsel makes a sweeping generalization about prior lawsuits plaintiff Scott filed against defendant Moon. Counsel, Mr. Harden, failed to mention distinguishing factors in those cases. He failed to identify the types of cases they were: appropriation, torts of false and negative light, and defamation, as well as the reasons they were dismissed. Plaintiff Scott presents below a more detailed, accurate, and factual outline of litigation between Plaintiff Scott and Defendant Moon. Oh, this will be great. Although Plaintiff Scott also presented this information in her motion to strike, she does not present it again here to be redundant. Defendant Moon by counsel brings allegations alluding to Plaintiff Scott being a vexatious or malicious litigant in both his motion to set aside default and motion to dismiss. Motion for a protective order as well. These false allegations are an attempt to silence plaintiff from seeking relief before the court and an attempt to conceal the identities of Jane Doe 1 and John Does 1 to 3. Plaintiff Scott's additional defenses to defendant Moon's false allegations of victimizing defendant Moon are in plaintiff's reply to combined memorandum. Okay, lots of words, not saying much. May 2017, Plaintiff Scott files in Wise County General District Court an appropriation claim against Moon under Virginia Code 80140. Case is dismissed on the grounds that the plaintiff needs to demonstrate that defendant Moon is making money from using her name and photo, although the judge presented no case law to support this ruling. That's what an appropriation claim is, Melinda. That's what appropriation is. It's taking someone's likeness to make money. It's a promotion, a publicity promotion. Like if I take your face and make fun of you, that's not appropriation. It's if I take your face and advertise that you support the thing to make me money. It's about taking someone's importance image and using it. June 2017 to December 2017, Plaintiff Scott appeals to the Wise County Circuit Court Ms. Scott's appeal to the court is dismissed because she did not plead every fact in her original pleading filed at the general district court level. Case was not dismissed because she did not have an actual claim. Ms. Scott still has the legal option of refiling an appropriation case against Defendant Moon upon correcting the error of omitting every fact upon which she relies. I guarantee you she read this ruling wrong. I guarantee you she read this ruling wrong. The Virginia statute of limitations is 20 years after the death of a person for filing. You don't have an appropriation claim, Melinda. You have to show why someone would make money off of your face. Melinda Scott loves these fake eyelashes. Melinda Scott breastfeeding bags. That's the type of stuff. Melinda Scott breast pump. For women who just can't stop having babies with 9 husbands or whatever. Like, that's what you would have to do. It'd have to be for a product that someone would go, hey, Melinda Scott's buying. Like, LegalZoom. Melinda Scott supports LegalZoom. File lawsuits all day. LegalZoom right now. Brought to you by Melinda Scott. That would be appropriation. 2018, instead of refiling the appropriation claim, Plaintiff Scott in state court, Plaintiff Scott transfers the claim to federal suit against Moon due to the changing and growing content on Kiwi Farms between 2017 and 2018. The case is dismissed because Plaintiff Scott did not, A, mention in the body of the complaint that Moon wrote some of the articles himself, so section 14. Plaintiff Scott included this information in a footnote. Stop using footnotes. If the court's told you that you can't... The complaint, but this court did not find that sufficient to demonstrate that Defendant Moon wrote the articles himself using his own user account. Stop putting all this shit in footnotes. Like, if you're not a lawyer, don't use footnotes. Just write everything in line. Cite everything in line. It's fine. Just cite it in line. Don't put it in footnotes. Most lawyers don't use depending on where you are. In Minnesota, state civil court, you don't use footnotes. You don't need them. Go ahead and drop the citation in the line with it. That way judge isn't like, Remember, judges are 150. They have to have their screen zoomed in so far that they have to scroll down to the footnote and they have to scroll back up, even if it's one line apart. Because their macular degeneration makes it, they're like this, right? Here's a judge reading a document. Here's what the computer sees. Okay? That's what the computer sees. Oh my God. And B describes the reason that Defendant Moon does not qualify for immunity under CDA 230. Western District of Virginia grants Defendant Moon immunity under CDA 230. Yes. Of course it does. 2018, Plaintiff Scott brings a separate... Is the same age as me? Well, that's how I read the computer, too. 2018, Plaintiff Scott brings a separate claim against Defendant Moon for defamation. Western District of Virginia ruled that Moon's statements were only rhetorical hyperbole. And for the remainder of the complaint, grants Defendant Moon immunity under Section 230. In this complaint, Plaintiff Scott did not describe the reasons that Defendant Moon does not qualify for immunity under CDA 230. Well, you should have. I guess that was a mistake. Distinguishing factors of this lawsuit in 2020. Here, Plaintiff Scott clearly stated all the reasons that Moon does not qualify for immunity under 230 in her complaint. Not going to be good enough. Plaintiff Scott stated that Joshua Moon and not a third party has created content about Plaintiff Scott on his website. This is an IIED case, not appropriation, defamation, or other torts. Plaintiff Scott has not previously filed an IIED case against Defendant Moon. Is he lying, though? Because if your allegation is that the IIED is caused by lies, then you're actually just trying to hide a defamation case as intentional infliction. It'll be treated the same as a defamation case and thrown out as it rightly should be. Wherefore, because his motion to set aside judgment has not presented any valid reason to explain the disappearance of the summons and complaint, because he was served properly as a business. A person cannot be served as a business. A sole proprietor is just served as a person. Because if they are the business, and you have to serve them at the place of business, and you have to serve the manager, who is the sole proprietor, and you have to serve the person at the business during business hours. You have to give it to the sole proprietor, not to somebody else. Like, that's what you got to do. If they're a sole proprietor, then they're a sole proprietor, and you have to hand the document to the manager, who is the sole proprietor at the business, which is just like handing it to them in person, literally anywhere else. Like, so you could hand it to him in a bathroom. You could hand it to him at a concert. It's like a Dr. Seuss book, right? Yes, I'll serve you on a train. Yes, I'll serve you in your brain. Yes, I'll serve you in a house. Yes, I'll serve you riding a mouse. Like, you have to give it to them. I respectfully ask for this. Melinda Scott, pro se. Okay. Here's our memorandum of law. Now, generally speaking, your motion is shorter than your memorandum by a significant amount. Like, all of her stuff should have been in the memorandum. But I guess. Memorandum of law in support of plaintiff's response to defendant's motion to dismiss. Okay. Legal standard in the Fourth Circuit to overturn entry of default order. It's going to be the same thing, basically, but let's see. Defendant has filed a motion to dismiss. However, the motion to dismiss is inadequately positioned before this court because they have not met one of the other major requirements for setting aside an entry of default. Fourth Circuit has provided 6 factors to be considered when ruling on a motion to set aside entry of default. Balcom versus Do-All Company. Like, this looks right. Notice she has an inline citation here, but a footnote here. Don't do both. Pick one. Pick one. If you're going to do footnotes, then you footnote right here and you cite it down here. If you're going to do inline citations, then you delete this bullshit because it's not necessary. You just write another sentence. Fourth Circuit maintains the legal standard that in order to overturn an entry of default, the defaulting party has to show what degree they were personally responsible for the default. 0. He was 0 personally responsible for the default. The answer to that is 0. It's 0, it's 0, it's 0. A meritorious defense in and of itself is not sufficient. Standard in the Fourth Circuit to overturn a default is not only the litigant brings a potential meritorious defense that might allow a court to find in their favor, but also a valid reason for lapsing in a default. Fourth Circuit has ruled that where a party bears personal responsibility for a delay in responsive pleadings such that default is entered against it, the party must adequately defend its conduct in order to show the excusable neglect. They have to bear the responsibility first and then have excusable neglect. But if you don't bear any responsibility, you don't have to show your excusable neglect because you don't have any responsibility. If you're not served, you can't be responsible for failing to reply because you weren't served. Here, defendant shows no excusable neglect for not responding to the summons and complaint that was delivered at his business address. U.S. Marshal certified under penalty of perjury that he delivered to defendant Moon's business address the summons and complaint, but he didn't hand it to the business, and you're not suing the mother business. Defendant Moon has not yet presented any storyline or asserted any reason explaining how the summons and complaint disappeared into thin air. All he has to do, literally all he has to do, is say to the court, I am not Lolcow LLC. That's it. Like, just scribble on a napkin and mail to court. MALE to CORT. Mailed to court. And you put that in the mailbox. And all it says in crayon that's been drooled on by Spectre is, I not lolcow LLC. I Joshua Moon. That's it. Literally it. Like, her entire argument is about suing lolcow LLC. In Broadcast Music Inc. Oh, wait. So, yeah. Broadcast Music Inc., the court determined that the defendant had no personal responsibility because he did not receive the service of process. You just laid out why he doesn't have responsibility. You just cited the case law for why he's not responsible. Here, Defendant Moon did receive service of process. Nah, I didn't. That's it. At his business address, and therefore is responsible for the whereabouts of the summons and complaint. Guess what, guys? If you're at work, like let's say you work at a bank, and someone mails the bank a service of process to you, you haven't been served. It's amazing how this works. A party's neglect is excusable when the party inexplicably loses the summons and complaint after service. He doesn't allege that he lost it. Here, Defendant Moon's lack of record keeping of the summons and complaint is inexcusable as well. I don't think he alleges that he lost it. He says he never got it. No, AWIG, we read the Florida statute on service. It says, anyone designated by law. Legal standard of Fourth Circuit for invalidating service. Plaintiff properly served the defendant as a business. Fucking God. Oh, damn it. According to Virginia and Florida statute, service of process was not defective under Rule 4E1. The summons and complaint was served within the time limit allowed. Even before the defendant received the notice of default in the mail, Defendant Moon already knew a lawsuit had been filed, which he was named a defendant. That doesn't matter. Oh, this is going to be the constructive service. This is great. Oh, I can't wait for this argument. Fourth Circuit has stated that actual or constructive notice that a lawsuit is forthcoming is a factor that makes defendant personally responsible to act. So here she cites. Damn it. Kramer v. Jotun Paints. Let's take a look at this. I've got the cheesy thing here. I don't actually have the, I don't have my good research tools up. Let's see. Okay. Cases were both commenced by complaints filed in the circuit court for Baltimore City close to the 90th day after the receipt of the plaintiff's notice of right to sue. Both complaints were filed on June 4th, day of Miss McCauley's deadline, and 10 days before Mr. Kramer's deadline. On June 5th, circuit court issued summonses to the plaintiffs to be served upon the defendant within 60 days after the date of issue. As explained by the applicable rule, a summons unserved within 60 days shall be dormant, renewable only on written request of the plaintiff. Plaintiffs failed to serve the defendant within 60 days, and the summonses expired on or about August 5th. Plaintiffs took no action until November 26th, when plaintiffs' counsel requested reissuance of the summonses, which were reissued on November 27th, and were eventually served on the defendant's registered agent on December 13th, 2001. After service, removal was made to this court. Defendant argues that both causes of action are time-barred because the plaintiffs failed to serve process within 120 days of the complaint as required by Federal Rule of Civil Procedure 4M. More specifically, the defendant argues that the expiration of the 120 days revived the running of the 90-day period in which plaintiffs could bring a Title VII claim, and because that 90-day period expired before process was served on December 13th, the suits are barred. To support this conclusion, the defendant cites various cases, including Arabian versus Bowen. Plaintiffs have filed perfunctory oppositions to defendants' motions, simply pointing out, and quite correctly so, that the 120-day period of service was a process required by the federal rules does not apply to cases in which service was carried out before removal to the federal court. The fact, however, that the defendant improperly relies on the 120-day period for effecting service under Federal Rule of Civil Procedure 4 is of no consequence. As recognized in Eccles, before removal to a federal court, state law governs service of process in this case, which provides for a 60-day period in which service must be effected before summons expires. As explained below, the plaintiff's causes of action are barred under both federal and state service rules. I think she read the wrong case. Because this says the plaintiff's causes of action are barred under federal and state service rules. 90-day period provided for in Title VII is at the very least analogous to a statute of limitations and is certainly subject to principles of equitable tolling. Defendant asked this court to find Title VII's limitations period should not be told in this case, relying on federal law as follows. Plaintiff has 90 days from receipt of notice to sue. Receipt of notice of right to sue to commence a Title VII action, either state or federal court. Upon filing suit, the plaintiff's 90-day limitations period is subject to tolling. Upon filing suit in federal court, the federal rules apply, and therefore the plaintiff must effect service on the defendant within 120 days. Plaintiff fails to effect service within 120 days, the summons expires and the 90-day limitations period recommences, unless the plaintiff can demonstrate that the limitations period should be told despite expiration of the summons. Let's see. Thus, if the federal rules of civil procedure apply to this case, plaintiffs would have to show that either that the defendant was served with process before the summons expired, or that although the summons expired, the 90-day limitations period should be told for other adequate reasons, as indicated in Arabian. This would require a showing on the plaintiff's part that they exercised due diligence in the service of process. From the face of the pleadings, it is clear the plaintiffs here failed to serve process within 120 days, and therefore the summonses would have expired under the federal rules. Moreover, the plaintiffs have made no showing of diligence in this case. Plaintiffs have offered no evidence of even an attempt to serve defendant until December, when service was actually made on the defendant's registered agent. Resident agent should have been registered. Moreover, the fact that plaintiffs waited over 3 months to renew their expired summonses belies any reasonable argument of diligence. What the fuck is she quoting? Everything in this document goes against her argument. All right, sorry guys. This got out in the weeds. But she is using Kramer. Did I grab the right one? 183F supplement second. Yeah, that's it. Let's see. For these reasons, it is clear that upon filing their initial complaint in state circuit court, the 90-day limitations period was tentatively suspended, came back into renewed effect on or about August 5th, and the original summons is expired. Thus, renewing the summonses 3 months later and finally serving the defendant's resident agent on December 13th was insufficient to preserve the Title VII claims, absent circumstances justifying tolling, none of which is advanced here. Such a result in the case initiated in state court, moreover, is consistent with what the results of inaction after initial filing in federal court would have been, resuming the running of the 90-day limitations. For these reasons, a separate order will be entered in the case granting the defendant's motion to dismiss, as plaintiff's Title VII claims are untimely, and there's absolutely no reason advanced to toll the running of the 90-day limitations period under either federal or state law. She just cited a case where they lost for not being served. And she cited that case in support of the idea that they should have known? It's the literal fucking opposite. It's the opposite case. It's the exact opposite thing that she should have put in. Not that there's a single case that would support the idea of constructive notice. It doesn't matter. Bad Vibe says, "Hey Melinda, you can lose something you can't lose something you've never received, like sanity." I mean, Fourth Circuit has stated that actual or constructive notice that a lawsuit is forthcoming is a factor that makes defendant personally responsible to act. Number 3. That is literally not what it says. Let's just look in here for constructive notice. Here we go. Is the only place it says it. In the cases now before the court, it is undisputed the plaintiff failed to effect service of process. Moreover, the plaintiffs have offered no evidence that any attempt was made to serve the defendant before the expiration of the initial summonses, or that the defendant was on actual or constructive notice that a lawsuit was forthcoming. That doesn't... Melinda... She just... This is why you hire a lawyer. This is why you have to... Pro se litigants can do it. They shouldn't, but they can. But this is why you have a lawyer. What they're saying is in regards to a Title VII claim that has a specific 90-day window to be brought after notice of a lawsuit is given. The reason they're talking about actual or constructive notice is because there are arguments that that 90-day period can be told at a time, told, T-O-L-L-E-D, at a time that is different from when service is affected. That has nothing to do with constructive notice being effective service. You dummy. It has nothing to do with what you're arguing here. It has a lot to do with Title VII claims and their time-barring 90-day window. It has nothing to do with the overall service of process. This is one of the worst cases you could have cited, also because they fucking lost on the issue that you're trying to say that you should win on. Okay. This is just a flat-out misstatement of the law. Joshua Moon even stated online that he intended to reply to the lawsuit on July 10th, 2020. Doesn't matter. You can say that all day. Joshua Moon had constructive notice that the lawsuit was forthcoming to be served upon him. That's not a real thing. There is no constructive notice in service. A minor technicality like the omission of... This should be under a separate subheading. Melinda, get on the fucking ball. Of Western Circuit of Virginia is insufficient to dismiss a complaint or even overturn a summons. Fourth Circuit has determined that when there was actual notice, there isn't actual notice. Every technical violation of the rule or failure of strict compliance may not invalidate service of process. You forgot to emphasize the may. This is the important line. It may not, but it also may. And you don't talk about why this is like... This is another problem with being a pro se litigant. She's citing cases, but she's not talking about why this case is like or dislike the case that's cited. Legal standard of the Fourth Circuit for amending a summons. Should this court determine the summons was defective, plaintiff also qualifies for an amendment to the summons under 4A2. Yes, you do, but you'd still have to serve it. Leave to amend the summons is the appropriate remedy. Like, leaving to amend the summons is fine. You'd still have to serve that summons. And you haven't done so. So he still wouldn't be in default. Your argument here defeats default judgment. That's it. Section 3, no default judgment. Because if the summons was defective and the cure to it is to amend the summons to make it effective, which is true, that form defects are often fixed by amendment. But you still have to serve the amended summons. Legal standard for what constitutes a meritorious defense. Here, defendant claims that he has a residence in the European Union. However, defendant fails to give any evidence whatsoever that claim is true. He doesn't have to prove that it's true. You have to prove that it's not true. Fourth Circuit has stated that simple denials are not enough to rise to the level of a meritorious defense. I don't think his status of living in the UK is his meritorious or living in the EU is his meritorious defense. Pinpoint IT Services, the court stated that the burden for proffering a meritorious defense is not onerous, but the defenses must allege specific facts beyond simple denials or conclusory statements. Okay. Here, the defendant does not allege specific facts proving that he actually has a residence in the European Union. I mean, the specific fact is that he doesn't live in the United States. What? Conspiracy says, does she think this is fun or something? I legitimately think Melinda Scott is addicted to filing lawsuits. I think she is legitimately an addict. I think she needs rehab. I think she needs help. I think she needs to be prevented from filing them for a while. I think that would be better for her mental health. In actuality, Joshua Moon has significant ties to Florida. That doesn't make him a resident, including a residence, which is what allows him to be an active registered Republican. The claim that he lives in the EU is another dilatory tactic to evade service. No, I don't think it is. I don't think that's a dilatory tactic to evade service. If he actually lives in the EU, that is a specific fact that is sufficient. Like, what does she want him to do? Prove you're not in Florida, but I'm not, though. He did not renew his business license for Lolcow LLC after Plaintiff Scott sued him in 2017. So, although Florida statutes require him to register and have a registered agent, you're not suing Lolcow LLC. Maybe you should sue Lolcow LLC. You could do that, but he doesn't have to register and have a registered agent if the business doesn't exist anymore. You're arguing that Josh Moon is Kiwi Farms and not Lolcow LLC. Sure, make that argument. Maybe he has a different LLC in a different state. Have a little more whiskey here. Legal standard for stating a claim. Plaintiff Scott has adequately pled facts to state a claim for the intentional infliction of emotional distress against Defendant Moon. Her complaint contains sufficient facts and elements of the tort, even after review of the record, including the complaint. That's not what default. That's not the review of the record. Claim is facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Plaintiff Scott has pled adequate facts in her complaint, and defendant's 12b6 defense fails as a matter of law. No, you haven't. I mean, that's a fine statement. That's actually a fine statement of legal writing. Not because of the default, though. Fourth Circuit has determined that an actor is a state actor. Oh, this is where Josh is now a Fed. An actor is a state actor in any of the following three situations. When a sufficiently close nexus between the actor and the state exists. When the state exercises coercive power over the actor through extensive regulation or significant encouragement. Or the actor is performing a traditionally exclusive public function. Here, a few of those conditions apply to Defendant Moon. On one count, Defendant Moon was significantly encouraged by Wise County Department of Social Services to forward the information from his website. That is not coercive power. On a second count, Defendant Moon acted to supply exhibits as evidence to Wise County Department of Social Services, which is a function left to a Commonwealth's attorney. Nope. Who represents a government agency. Nope. And collects exhibits for government agencies. Nope. Anybody can forward. Anybody can do it. Supreme Court has stated that the required nexus may be present if the private entity has exercised powers that are traditionally the exclusive prerogative of the state. Evidence collection for trials are the prerogative of the state. In a Commonwealth, attorneys not of private entities such as owned, controlled, or operated or involved as Defendant Moon was. Show me a citation where it says that. God damn it. Plaintiff Scott clearly stated in her complaint that the content from Defendant Moon's website was forwarded and distributed to employee emails of the Wise County Department of Social Services. Defendant Moon was orchestrating the use of government employee emails to act at the level of the state employee. No. It's action. Guys, if you've sent a document to a state agent employee email, like when I email a prosecutor, I'm now an agent of the state. Done. Defendant Moon was orchestrating, this action to send information to child welfare employee emails in order to report alleged child abuse and neglect has no foundation in state or federal law. What? There's no legal precedent for allowing citizen reporters to use government employee emails to privately communicate? What? Virginia Social Services Administrative Procedure governs that anonymous, mandatory, and other reporters call Department of Social Services to report child abuse and neglect. I don't think it governs that. I don't think it demands that. Documents are not presented unless there is a hearing in a courthouse so as not to deprive an accused individual of their right to due process. That's not true at all. None of this is true. This involvement of Defendant Moon using government employee emails to communicate with a child welfare agency makes him a state actor acting in concert with and on behalf of the government agency to collect exhibits that would otherwise be used in employee files and for court hearings. Defendant Moon, no citations for any of this. Defendant Moon acted under color of law by orchestrating a situation in which exhibits from his website would be forwarded to Wise County Department of Social Services employee emails. This is interesting. She doesn't say he forwarded him. Orchestrated a situation in which they would be forwarded. I don't think Josh sent the emails. One final consideration often arising in the resolution of state action questions is whether there must be a nexus between the indicia of state action and the specific acts comprising the alleged constitutional violation. That is, under some of the circumstances set forth above, we have required that plaintiff establish a connection between the color of law and the alleged violation. Okay. Here, Defendant Moon's action done under color of law violated the plaintiff's 5th, 14th Amendment rights. This is a conclusory statement and should just be fucking ignored. Person acting under color of state law must either be a state actor or have a sufficiently close relationship with state actors such that a court would conclude that the non-state actors engage in the state actions. Never going to happen here. Nexus Services is a case in which a 1983 complaint was brought against a defendant. Talk about the case. Talk about the case. I bet Nexus Services was a government contractor and was acting as a government agent, like with specific authority that would be delegated to the government was given to their contractor. I would put money on that. So then you're going to have to show privity of contract between Josh Moon and the state. Defendant Moon can be held to the standard of Nexus Services, which you don't lay out. Whether he is a state actor or simply acting under the color of law, even if he is not determined a state actor, his involvement together with the John Does create a sufficiently close relationship that makes him liable under 1983. Nope, it doesn't. It's not even close. Defendant Moon's unwillingness to give information leading to them can also be construed as admission of being further involved with the Wise County Department of Social Services as a state actor in a conspiracy to deprive plaintiff of her constitutional rights. Under Rule 37, refusal to engage in discovery can be construed as an admission. He can't refuse it. You still haven't served him. Legal standard in the 4th for CDA 230 immunity and exceptions to 4th Amendment immunity. Plaintiff Scott adequately pled in her complaint sufficient facts stating why he did not qualify for immunity under 230. Fourth Circuit has named several reasons an internet service provider might not qualify for immunity under 230. In Nemeth, which she doesn't actually cite Nemeth very well. Oh, it's cited down here, I guess. Court stated that in order to have, she should have the full citation up here because it's the first time she's citing it. Court stated that in order to have immunity, the website owner could not be in the act of encouraging illegal content. There's no illegal content. Building upon the Ninth Circuit, it said a website owner who does not encourage illegal content or design its website or require users to input illegal content is immune. Okay. That's actually not what you're saying. You're saying that this is a limiting phrase, but this isn't a limiting phrase. This is expansive. This says a website owner who does not do this is immune under CDA 230. But other website owners, even if they do this, might be immune under 230. Might. It doesn't mean the converse is true. Plaintiff Scott adequately alleged in the complaint in this case, Defendant Moon permitted illegal defamation on his website. Permitted is not encouraged or required from other users. He is also responsible for creating the environment where he encouraged cyber stalking. Creating an environment where he encouraged. You have to show this. This is conclusory. Plaintiff Scott also stated in her complaint that Defendant Moon did not qualify for immunity because he interacts on threads, develops content, distributes information, has the ability to edit content on threads. That's not how that works. It's got to be specific to his statements. Oh, I'm dying. I need this to be done. Court ruled that the strict liability standard normally applied to original publishers for defamatory statements, rejecting Prodigy's claims that it should be held only to the lower knowledge standard usually reserved for distributors. Court reasoned that Prodigy acted more like an original publisher than a distributor, both because it advertised its practice of controlling content on its service and because it actively screened and edited messages posted on its bulletin boards. The argument is that Josh is a publisher. Okay. Here, the facts are the same for Defendant Moon. His actions in developing, editing, and controlling content on threads make him not qualify for immunity under CDA 230. It's all adequately stated in the plaintiff's complaint. That's an interesting case. I'll have to read it. Zarin versus America Online. 1997. Just a reminder of how old 230 is. Okay, so there you go. There's this thing. All done. I've both mailed a copy of this memorandum to defendant by counsel and at the email address. Perfect. All right. Woo! That's done. That is done. That is a shit document. As a shit document. It's time to grift likes. Hey guys, hit like on the stream. Go ahead and hit like. Get it up over 1,000 likes. I'll drink some whiskey. We'll have a good time. It'd be great. Thank you. Much appreciated. I mean, only if you like it. If you don't like it, don't hit like. But if you like it, hit like. That'd be wonderful. Okay. Fuck, that was a boring ass filing. Really stupid. Melinda is an idiot. Jesus. Okay, let me find this. I've got the Legal Eagle. I apologize for the amount of soy you're about to be introduced to. Look at it. Look at it. Look into the soy. Look into the soy. Look at it. Not the Photoshop. That's him. That's the opening frame of this video. Okay, let me make sure I've got the audio set up here. Okay, this is Legal Eagle. And this is his video on Section 230 repeal. This is a Legal Eagle short. A new thing that YouTube is promoting. And I don't understand it because as a grifter, I don't want to make non-monetized content. But shorts are under a minute long and they are not monetized. And I think they show up like down below, down on your phone, like down in your scrolling, like you'll get a list of these stupid little vertical shot videos. Every one of them has to be vertically shot. And that you get a list of those videos. And they're, I guess, to drive subscribers, but not give you monetized content. They have to be under a minute. So this is really short. We're going to add some commentary to this. If you're not familiar with Legal Eagle, he's one of the most popular legal YouTubers that exist. 1.49 million subscribers, up from 1.48 million yesterday. Shorts that I've seen have a ton of views. Yeah. I don't know what his, he posted this today and this has been sitting here. Oh, hey, let's do this. He went from 31,000 views to 80,000 views. Since I looked at this. So it's doing okay. God, look at it. Ah! Yeah. Yeah, he looks like a fucking chimp, doesn't he? Like you could just see it coming out of his mouth, like in him banging on something and then eating fleas or whatever, with the ears sticking out. God. Okay. Here we go. Let's do this. Okay, so this is his argument about repealing Section 230. What would happen?
As it seems to happen every few months, certain politicians are making a big stink about Section 230 of the Communications Decency Act.
Now, notice he said it would be devastating. I agree. Repealing Section 230 entirely would be devastating. If you're going to change Section 230, I do think there are changes that are needed. I think that changes, there have been some good propositions and proposed changes to Section 230 that could be done. That would be articulate and artful. That would still protect different companies while removing liability for people who do act specifically as editors. And it would be clear, ambiguous. They've got mechanisms in there for that, and that is the trick. How clear is the rule? 230 right now is not a clear rule. And the courts have deferentially read it to give tech companies unlimited sorts of authority to remove it. But let's go where Legal Eagle where his conclusions take us.
The funny thing is that if they were successful in repealing Section 230, it would be disastrous for those politicians because it does two things. Number one, it allows platforms to moderate, and number two,
platforms can moderate without Section 230. It does not allow platforms to moderate at all. It does shield platforms from civil liability, and this is the problem. This is the question that people have. Like, how much it shields them from all civil liability related to their moderation, including when they ban someone and cost them hundreds of thousands to millions of dollars. Like, imagine, for example, if Twitter banned Wendy's, right? Like, Wendy's has cultivated an advertising Twitter with millions of followers, and it reaches out to its customers directly. It also provides direct customer service, or well, some companies, I don't know if Wendy's does, but United Airlines, for example, is very responsive on Twitter. In fact, if you're ever on a United flight that gets canceled, DM them on Twitter. You'll get much faster service than calling them. You'll get much faster service than standing in a line. You can do these things. And to take that away from a company would be, potentially interfering with their ability to conduct business. So that type of civil liability exists. But they can moderate without 230. They don't need its help.
It provides a shield so that if a user posts something, the platform isn't responsible for that post. And
it does more than that. It shields them from all civil liability relating to moderating, which means if they remove someone, they're also similarly immune to a tortious interference type contact or type lawsuit related to, like, if their removal, like, let's say Donald Trump was conducting business over Twitter, specifically through direct messaging with a real estate investor in another country, and they banned Donald Trump's account because a Twitter employee was specifically looking at his direct messages, saw it, and then said, "Oh, we're going to ban it," and that interfered with their ability to gain that new business. You should be able to sue it. But if Twitter could plausibly argue that Donald Trump had violated their terms of service and that's why he was banned, under 230, if they said that the banning was related to moderation of content, like, then he would be, and if they could plausibly state that it was, even if it was actually about the other thing, then they could be immune to the civil liability for the interference that they caused. That's the stuff we don't like. That's the problem that we have. Okay, so it's immune to all liability, not just liability for what someone else says on the platform.
Well, a lot of people are mad about the moderation. If that shield was destroyed, a lot of those accounts, the ones that are at risk, that are peddling conspiracy theories and are possibly defamatory.
Peddling conspiracy theories is not illegal. You can peddle conspiracy theories all day, and there's no criminal or civil liability for the hosting platform, even without 230. That's ridiculous. There's nothing at all. In fact, there are publications that solely deal in peddling conspiracy theories. Defamation is a slightly different matter. However, you don't need Section 230 to be immune from the defamatory statements of others. Twitter is not responsible for a defamatory statement by Lynn Wood, for example. Twitter isn't responsible for that, even without 230. So the idea that 230 is required for that is silly. Now, where 230 is necessary is actually a place like Kiwi Farms. That is a much different question, because Kiwi Farms has things like active moderation, because they have, they have private forums versus public forums. They have administrators who are voluntary, who act sort of autonomously, but perhaps with the authority of the site and are given extra powers. Those types of things, and they're identifiable, and they post on the forums. Those type of things might open them up. Like, they could say that these are agents of Kiwi Farms or something like that. 230 is necessary for much smaller platforms. 230 is not so necessary for Twitter and Facebook. It's really not. And that's why they don't care if it goes away or is modified, but what they want is to be in on the modification. They want to help write the rules, and the reason they want to help write the rules is because they will write out competition completely.
Would be simply shut down. The first one to be shut down, probably President Trump's.
Probably not President Trump, due to 230 being removed. President Trump will be removed from Twitter, most likely after Joe Biden takes office. That has nothing to do with 230, because President Trump isn't defaming people under 230. Almost everyone President Trump talks about is a public figure by some stretch, because President Trump doesn't talk about non-public figures. He doesn't have time to know who those plebeians are. Who the hell does? He's only talking about typically government officials, representatives, newscasters. He's calling them all stupid, dumb, dummies, whatever. That doesn't matter. None of that's defamatory. These are public figures. He's not doing it with actual malice. He can argue very effectively in court that he believes everything he's saying, that he has reason to believe that these people are incompetent, or that those are just mere opinion statements, and that there's nothing defamatory about it at all. He is not worried about himself in regards to 230, you fucking moron. There is no reason to think that Trump is somehow at risk for 230. The person at risk for 230 is like no one. Twitter already removes people on a daily basis who are not economically viable. There's no fear of removal that's created by having 230. Twitter isn't like, well, we would remove them, but 230 insulates us, so we won't. Of course they're not. They just fucking kick you off anyway. This is the dumbest thing.
So as the old proverb says, be careful what you wish for. I did a whole video on this in the past, check it out. And if you like this video, check out my other Eagle Briefs where I cover the legal issues of the day. And as always, I'll see you in court.
Oh, God. Oh, God. He won't see you in court. That'd be like me saying, I'll see you in court. No, I won't. No, he won't. What's he talking about? He's not going to see anybody in court. Here, let's check this out. Let's see
Why can't we just sanction Sydney?
Here we go. Let's see what he says. I've not watched this. This is a dry watch. A dry watch. Every fucking face he makes is irritating.
Why can't we just sanction Sidney Powell to stop her from filing meritless lawsuits? That's the question that I've gotten from so many different people. And the answer is actually yes, generally. There is a procedure to sanction lawyers. It's called Rule 11 after the Federal Rules of Civil Procedure Rule 11. But the problem is it's cumbersome, and judges, like other lawyers, don't like to sanction lawyers. Why? It's the same reason that sharks don't like to bite other sharks. Professional.
No, it's not.
Courtesy, and also the fear that if you bite someone else, they might bite you eventually. But as it turns out, one defendant is willing to go to the mat against Sidney Powell. Lawyer.
Notice what he did there. Notice what he... Well, judges aren't willing to sanction Sidney Powell out of professional courtesy, like a shark won't bite a shark. No. No, no, no. That has nothing to do with it. It's not professional courtesy. It's the fact that preventing someone from filing a lawsuit is a deprivation of their liberty. And to do so is an onerous process that must be done carefully and exactingly. It's why retarded people like Melinda Scott can go ahead and file lawsuit after lawsuit after lawsuit. Or Russell Greer, the human typewriter, can file lawsuit after lawsuit against Taylor Swift without being labeled a vexatious litigant, or having Rule 11 sanctions filed against them. It's because to deprive them of the ability to file a lawsuit is a deprivation of a fundamental right, and it has to be done carefully, narrowly, and specifically based on facts. Not based on the fact that you don't like the lawsuit. If Sidney Powell is bringing lawsuits in good faith, she's not vexatious. And the fact that her lawsuits are being dismissed for shit like standing, that doesn't make you a vexatious litigant. That doesn't make your lawsuit frivolous. And these are complicated and novel questions. Of course, Legal Eagle's going to gloss over all of this stuff. The election lawsuits, anybody who tells you they know 100% how these election lawsuits are going to go, they're lying about that. They're lying. There's not enough case law to know how they're going to do it. They did this in 2000. They said that there was no way the Supreme Court was going to get involved in Bush v. Gore, and then they did. Now, I'm not saying the Supreme Court or any court is going to get involved in 2020 election lawsuits, but the idea of saying that they definitely won't, to the point where it is sanctionable to suggest that they might, is absolutely ridiculous. These issues are not litigated with frequency. The circumstances around them are unique and novel. There's no way to know if a court will take these on or not. You can make good guesses. We can say, you know, a court's not going to take this because the courts don't want to deal with it. I've been doing it. Barnes, Viva, Uncivil Law, Nate the Lawyer. Everybody's been making pretty accurate predictions about what cases the courts are going to take. And at this point, we're all saying, look, they're going to dismiss this for lack of standing on every single case because that's what they've been doing. Not because that's what they should do, not because there's a bunch of case law that says that they have to, but because that's what they've been doing this year. Next year, it might actually be different because doctrines of standing and latches are so flexible that you don't know if the court's going to actually apply them. It gives them a level of discretion. Not supposed to, but that's what it does. So this idea that we would get Rule 11 sanctions for filing novel, complicated election lawsuits and losing is ridiculous. And Legal Eagle should just say some short version of that, saying, well, you know what? Sidney Powell filed some lawsuits. She lost. I don't agree with them, but these are novel and complicated questions, and therefore we're not going to sanction lawyers for asking them, because if we sanction lawyers for asking novel and complicated questions, we would never develop new law. That's all he had to say. That's it. That's it. But he's a partisan piece of shit who has no idea what he's doing, and he's just grifting the shit out of his audience. These short videos are probably written by him and not one of his corporate overlords, and he's a fucking garbage YouTuber. I hate him. I think he's trash.
Lawyers for the city of Detroit have filed a Rule 11 motion for sanctions against Sidney Powell and her team of crackenologists. It might be one step in getting Sidney Powell to take a step back before she files the next meritless elections lawsuit. Please subscribe to the channel. I'm going to try this out, see if I can do a Daily Eagle every weekday.
Please don't. Please don't do a Daily Eagle ever. Please don't do any more Daily Eagles. Unless it's a Daily Eagle off of a cliff. All right. Okay. Let's do chats. Let's do the chats and then let's wrap up. Yeah, eagles can fly. Daily Eagles off a cliff, that'd be just a takeoff. You'd soar off into the clouds and never bother anybody ever again. How many eagles do you see on the average day? I barely see any, and I live by a bunch of bald eagles. Hell, there's probably a bald eagle that nests within 500 yards of my house. Yeah, we'll do some Twitch tonight. I don't think we're going to do a movie tonight. Friday. I don't think we're doing a movie tonight. I forgot the schedule. It's like Monday and Wednesday, movie. Tuesday and Thursday, video games. And then Friday, you know, whatever. You told me to write it down. You did. You did. And I didn't do it. I'm like, no, I'll remember. Sucker. Okay, the Dragon's Treasure. That's dragonstreasure.com. It's the harmony of tea and anime. If you like tea, you like anime, go to dragonstreasure.com. Buy some tea accessories. He says, coupon code Nick's Nose has been extended by 5 days until the 6th. Nick's Nose is 6 days long. How long can we make his nose? There's a promotion going on right now for every $50 spent, it gets extended by some time. And we're trying to see like what level of Pinocchio my nose will get. TV Goes Live says, hey Nick, a local smoke shop sells hand-rolled Honduran cigars and they're legal to mail domestically. If you want some, just let me know and I will send them with the snacks. Look, if you want to send me cigars, I'm not going to turn it down. But my smoking cigar days are pretty much limited to spring, summer, and fall. Winter, I'm not standing outside smoking shit. Night of Hopex says, I don't have to tell you I'm a loyal supporter of yours, buddy, but I watched the New Year's Hope video, and that thing is bullshit. You didn't give a plan or a strategy for fixing anything, which is fine. There isn't one right now. That's just reality. I didn't tell you to have a plan. I don't have a fix. I said don't let people discourage you. Don't let people tell you that you're a traitor for asking questions. Have hope in everybody. Like, there's no plan in that. Hope isn't a plan. Hope is hope. So, but yeah, you don't, I mean, I don't know. You don't have to like the video. I'm going to like force it on you. Xander's Rant says, your New Year's Let's see. Your New Year, New Hope thumbnail looks like the mad face photoshopped with a happy smile, or the smile from Joker's gas. Will you be putting Doug's leather book up there? You need to get rid of that pop filter and get a dead cat. What? That doesn't make any sense to me. Yeah, if when Doug's book comes in, I'll probably put it on the shelf. Yoshken says, hey, Happy New Year, my favorite late night legal boomer. How's the new year been for you? Great so far. Are you doing Twitch night? Yes. If so, is it a watch party or gaming? Gaming, I think. Vote by a straw poll is the only vote that matters. Crusader Saracen says, the whole family and I have been working 7-day weeks for several weeks now to keep up with the demand at our restaurant. So thanks for the streams, which help me relax after. Tough, but we count our blessings that we're doing so well right now. Godspeed, my dude. I'm glad you and your restaurant are doing well. Many restaurants are really struggling, so very, very happy to see that. Silky Johnson says, hey, Nick, I, like many, have run out of fucks to give. These pieces of shit have jacked off into the face of the people and the rules and the laws, hell, even the Constitution. So if they get pulled out of their house and pew-pewed, oh well, too bad, so sad. Damn. Regal Beagle says, hey, as a YouTube-approved lawyer, I take great offense to your assertions of my perceived heterosexuality. Even though I appear AIDS-filled, it is a lie. I'm only HIV positive, not full-blown commie AIDS yet. Affidavits are not evidence. Pardons bad. Thank you, Regal Beagle. Hated 7 Days to Die says, Happy New Year, everyone. May we all have many laughs together in 2021. Women posting their L's online was great entertainment so far. Thanks. Oh, I love it. It's so funny. Night of Hope X says, hope is not a strategy for 2021. Not sucking dick. All I'm saying. It's not. No, hope isn't a strategy. It's just hope. Just hope. Have some. Have some hope. Find joy where you can. I find joy in stuff like these streams. Making fun of Legal Eagle. Making fun of Melinda Scott. That's my hope. Blackleaf says, 100K hype. You earned it for sure. Hey, thanks, buddy. I appreciate that. Steve Stevens says, been enjoying the other non-live content. I usually work early mornings and miss the sweet live streams. I'm a private security officer and appreciate these videos and streams when I can view. Hey, thank you, Steve Stevens. I'm glad you're enjoying the short stuff. There's a lot more to come. 200 Watt Studio says, no, like the short segments. Too short for you to get drunk. The drunker you are, Nick, the better. How about getting drunk and then shooting your videos? I can't get drunk during the day. I would love to sometimes, but I can't because I might have to drive a kid. I might have to do something. You know, if a kid gets hurt, I have to drive him to a hospital. Can't do it. That's why I drink at night. Kimberly Moriarty says, hey, it feels like I haven't seen you since last year. Happy New Year. I hope it's a good one. Hey, Kimberly, it is a good one. I hope you have a great 2021. Jared Smethers, welcome to Paralegal Status. You now have access to early access to the videos that I record during the day. V's Flat Desk Pepsi says, don't know what's bigger, Nick's nose or forehead. Nose. It is. I've measured it. Drewby says, Happy New Year, sir. Best legs in streaming. Hey, thanks. Thanks, Drewby. Appreciated. Brandon Cavallero says, get a cardboard cutout of Drex for the background. Bad Vibe says, it covers my whole face. Talking about your nose. Yes. Quasi Quirky Creation says, why did you change the bookcase? Trying to be like Legal Eagle? DM me for Mike suggestions for kids. Have 4 kids all wanting to stream. Cheap, good options. Like I said, I'm thinking of moving the bookcase and putting up a nice background. Maybe a sign or something. I don't know. Trying to figure out what to do. It's 2020. I've had this bookcase up there for 2 years. Deciding what to do in the background. Going into 2021. Retro Dude Man X says, saw your vid of hope for 2021. Just got a news of mine too. Doc told me I have a year or 2 left on me. So I'm starting to do my bucket list and live. Damn. That's very heavy, Retro Dude Man X. I hope your doctor's wisdom is falling short. And that you have many more years ahead of you. And that either technology, fate, or your own body, or even God will intervene, and that you have more left. But live life now. That is something we could all take note of. Barb Rogers, Little Miss Sunburn says, the macaw of law. Thank you, Barb. Bad Vibe says, if you get the big C, pray it goes to your nose. Then you have medical need to get that rhinoplasty done. Bad Vibe says, just kidding. Don't mess with the nose. It actually makes you more money than your hair. Damn. The hair stuff. You guys are brutal on the hair. I was never conscious about my hair, but now I am. James Valdez says, renminbi equals Chinese cash. And why can one lie to cops without repercussions, but not the FBI? Because the FBI is stupid. DJ says, the computer says trim your nose hairs, you boomer. Probably. Bad Vibe says, wait, what about the opposite? So hated our own has lawsuits flying out our ears from MS? I don't know what that means. Matthew Longstrath says, can you please give your new followers some idea why you are covering this lady's lawsuit? Second live stream, no idea what started it. Great channel. Oh, Matthew, sorry. If you're still here, Matthew. So this lady, I try to cover goofy lawsuits that happen on the internet. Or interesting lawsuits. Oftentimes related to internet personalities and internet drama. Melinda Scott is a crazy lady who has sued a website called Kiwi Farms. Don't go to it. Kiwi Farms is a website where people can post any kind of information. They can post addresses, names, whatever. And many people think that it is a haven of villainy and scum. And they're really right, all around. That's fine. They are scum and villainous and all of that stuff, right? That is definitely present on the Kiwi Farms. But that said, most of this stuff is legal. It is legal to do it. The other thing they do is they archive things that are interesting to the world. For example, they archive footage of mass shootings. They archive footage of crazy people at riots. They archive all sorts of stuff. And then they just preserve it so it doesn't get deleted by the internet at some point in time. Melinda Scott is mad because the Kiwi Farms talked about her on a forum. And unfortunately, that's just how it goes. That's the internet. Talking about someone on a forum is permissible. It's legal. Something you can do. We are allowed to express opinions, even if those opinions are, disfavorable towards someone. So she has sued because she is mad at the internet for talking about her in a way that she disagrees. That's that. Also, the first time I talked about Melinda Scott, she filed an ethics complaint against me for merely talking about her. And this is at a time where I didn't know anything about her at all. She filed an ethics complaint for just talking about what was going on with the person she's suing now. So that's one of the reasons we're covering it. She's kind of a recurring theme on the channel. I hope that answers your question. Thank you. Welcome to the show. The live shows are a vastly different animal than the short content. If you join from the short content, I do hope that people will come watch the live show, but they are way different. Different subjects, different feel, different tone. But all of this is me. I will never be anything other than honest with the audience. So, yeah, there you go. Bad Vibe says soy sauce biatch. Asia Fraser says, if you win a lawsuit, do you have to pay taxes on it? If you collect a judgment? I think so. It depends, though. Because it might, if you're being made whole for a loss, it might not be income. I think it depends on the type of judgment. Depends on a lot of circumstances. I'll see if I can get you a better answer on that. Jordan Jones says, hey man, I found your channel today. I want to say thank you for providing your content and your legal analysis. You're the man. Hey, thanks, Jordan. Welcome. Happy to do so. Angry Baneling says, Happy New Year, Nick. Hope we're still getting that 24-hour stream. And don't forget to apply for the 100K subs button. I want to see it on your wall. Yeah, I need to talk to my YouTube guy about it. But he's out for another couple days. So I'll apply for it. And then, once he's in, I'll ask him for help with it. Blaine 20 says, just pre-registered for Diablo Immortal on Google Play. Oh, no. No. Tell me how it is. Kate4394 says, hi, Nick. I'm the same Kate that was commenting a lot during your thought stream. Love your live shows, but my job, I can only watch you live on Fridays. Love listening to you at work the next day, though. Hey, Kate, thank you. Welcome. Welcome. Okay. We've got a couple more. Night of Hopex says, my desire is getting these masks off and keeping my job somehow. When I tell them I'm not getting a vaccine I don't want or need. But hoping that without any reasonable course of action that might get me there doesn't do anything. People are cornered, dude. I know. I don't. Again, hope isn't a strategy. Hope isn't a thing that accomplishes something. Hope is hope. There are other things you can strategize. You can try and do. You can talk to your employers. You can advocate. You can do all sorts of stuff. I don't know that they'll be fruitful, but hope is different than that. Xander's Rand says, when you get to 200K, you need to do a stream with a green screen, in a suit, and law books in the background. Dead Cat is another name for Mike Windshield, rather than the pop filter. After your yoga stream, it has to be with dress as a thought. Legal Eagle says, wiping my ass after I shit would be unprecedented. It would be an assault on our republic. It's not even close. Why don't we censure lawyers when they frivolously wipe their ass? Imagine if Hitler bribed you to wipe your political opponent's ass. Books Games Pottery says, hey, Nick, I, for one, loved your New Year's video. And I completely agree with what you said. Hey, thanks, Books. I appreciate it. Look, I'm just trying to encourage people. It's a new year. It could be a bad year. It could be a good year. But without hope, it'll always be bad. With hope, we can maybe get people positively moved for good. All right, guys. Thanks for hanging out tonight. I'll be over on Twitch in just a little bit. I really appreciate all of your support every single night and every single day. Thank you for giving me the best job in the world. And here's to a fantastic 2021. I'm going to play the outro now. And we'll see you over on twitch.tv/RicadaLaw for some chilled out video games. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass we hear laws planing tonight. From the wide shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we ask.